to the judges.
Welcome. My name is Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And it's really a pleasure to be here for the national finals. Congratulations on reaching this point. And I'm going to ask the other judges to introduce themselves as well, starting with Mr. Volpe.
I am Edward Volpe. I'm an attorney in Denver, Colorado. I'm looking very much forward to your presentation today. Congratulations on being selected for the national finals.
Hi there, my name is Caitlin Johnston. I am an attorney in New York City, joining you from my studio in Manhattan. And I was a We the People participant when I was in high school growing up in Indiana. So I know what it's like to be on your side of the table, but I never made it to nationals though. So you've already bested me. Best of luck.
All right, I'd ask the students to introduce themselves, please.
My name is Jack Bensing.
Hello, my name is Caleb Johnson.
Hi, my name is Caroline Flanagan.
My name is Shor Ramanujan, and we are all seniors in Mr. Ken Thomas's We the People class at Blue Valley Northwest High School in Overland Park, Kansas.
All right, well, thank you for that introduction. And again, congratulations. I'm going to read the question from Unit 5. And then once I'm done, then the time will start and your presentation will start. A result of the decision in Wisconsin versus Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may begin.
In 1971, the majority decision in Wisconsin v. Yoder said that parents or guardians can limit their children's access to education because of their religious beliefs. The First Amendment grants citizens the freedom of religion and protects rights which would outweigh the state's interest in compelling school attendance. We agree with the court's majority decision in Wisconsin v. Yoder that parents or guardians can limit their children's access in the name of religion, but we would contend that the children's constitutional interests were neglected. Specifically, we agree with Justice William Douglas's partial dissent that students should be able to weigh in on the decision to terminate their public school education.
Thomas Jefferson and James Madison believed strongly in the need for a civic education to produce an engaged and educated citizenry. In his letter, Madison wrote, quote, "The American people owe it to themselves and to the cause of free government to prove by their establishments for the advancement and diffusion of knowledge that their political institutions are as favorable to the intellectual and moral improvement of man as they are comfortable to his individual and social rights." The United States Constitution, however, contains no explicit language that mandates an education. The 10th Amendment dictates that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Therefore, the ability to enforce education is given to the states. The state of Kansas, for example, outlines its educational provisions in Article 6 of the Kansas State Constitution. The public school systems are supervised by the Kansas State Department of Education and is in their best interest to ensure all minors under the age of 16 receive an adequate education.
The 14th Amendment protects the rights to life, liberty, and property, and therefore the national government has an influential position in issues addressing equality in education. For example, the Federal Civil Rights Law, Title IX, and affirmative action limit discrimination on the basis of sex and race in institutions that receive federal aid. By doing so, the federal government can indirectly influence public school systems and state universities that receive national funding. In an attempt to provide all children with an equal and quality education, the federal government passed the No Child Left Behind Act in effect from 2002 to 2015. After the program failed because states could not reach the unreasonable standards of the No Child Left Behind Act, the Every Student Succeeds Act was passed, which gave individual states more flexibilities in setting their own standards.
The Supreme Court has difficulties in balancing religious freedoms with other rights and case rulings that are influenced by the justices and their interpretation of the First Amendment. At the beginning of the COVID-19 pandemic, state governments placed their states in mandatory lockdowns, implemented mask mandates, and restricted gatherings in an attempt to reduce the spread of the coronavirus. The suppression of religious gatherings in an attempt to reduce the spread of the virus is an example of the government balancing rights. Historically, the Supreme Court has used guidelines like the Lemon Test to assess the constitutionality of a law under the Establishment Clause. The three-pronged test found in the opinion from Lemon v. Kurtzman states that first, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances nor inhibits religion. And finally, the statute must not foster an excessive government entanglement with religion. In relation to education, the courts balance private and public education with its association to the child benefit theory. Originally introduced in Cochrane v. Board of Education and expanded in Everson v. Board of Education, the child benefit theory allows private schools to use state and national funding to supply items such as textbooks, transportation, and lunches to students. The child benefit theory outlines the distinction between the child and the institution. However, regardless of safeguards such as the Lemon Test, as well as the establishment and free exercise clauses, the courts will likely continue to have difficulty creating a religious and governmental equilibrium. Thank you. We are now ready for questions.
Well, thank you. And I'd ask you to put any notes you may have in front of you aside at this point. You talked about your agreement with the Yoder decision. And how should a student's right to an education be weighed against a parent's religious beliefs?
Well, a student's right to an education should be at least heard by the courts. In William O. Douglas's dissent, he said that the student should have at least been heard in the court case Wisconsin v. Yoder. As part of an analogy, I would tell you that when parents get divorced, students also have a say in which parent they want to spend more time with. So students should also have a say likewise on whether they should go to school past the 8th grade or not. They should at least have a say.
I would agree with Jack in saying that the students should be able to provide their opinion as to whether they would like to continue school. In the context of the Wisconsin v. Yoder case, the reason that the parents found it unnecessary for their child to continue an education is because they deemed that continuing their education would prove to be harmful to their Amish tradition and values. If the student believes that they should continue their education in the face of this, we believe and we would contend with, along with Justice William O. Douglas, that their opinion and their right to do so should be heard by the court before making a final decision, even though the parent is one that speaks for the family.
I would also like to add that in the decision, Wisconsin v. Yoder, the children, although they were not attending public education for their high school, they were going to continue on to a vocational Amish school where they would be learning continuous Amish traditions.
So is this panel saying that the child, if they wanted to continue their education past the 8th grade, would have to take their parents to court? Is that the proposal?
We wouldn't contend that it would have to go that far. However, we would say that the child should voice to the court through the hearing process. If the parent did not want their child to go to court, the child should be able to have the ability to voice their opinion as to whether they would want to continue going to a public school education or some sort of education, as opposed to an Amish traditional way of education that the parents would prefer.
And how should the judge weigh that? And maybe let's use a different hypothetical here with a religious sect that it has a policy of forcing young girls into marriages and childbearing before they turn 18. How should the judge deal with that tension between the child's interests and the parents' religious beliefs?
I think the best way that we can weigh the children's decision can best be seen through the analogy that my colleague had provided, which was like through divorce cases. The child's decision or the child's opinion is usually weighed based on their age or based on how much information they have based on their religion, for example, in this case. So for example, a very young child under the age of 5 would have less weight than a teenager, per se.
In the scenario you just brought up, the religious belief has to be well established. We also have to keep in mind of that too. So in Wisconsin v. Yoder, it was well established that Amish kids don't go to school past 8th grade. So in the scenario you just brought up, we would have to assess whether what you just stated is a well-established religious belief in order to rule in a case like that.
In addition to what my colleague Jack had just said, the argument that Wisconsin was making is that those additional few years of education would prove vital for those students to be productive and efficient members of society. However, the court did not find evidence the state was able to provide that, and they found evidence that Amish people could be considered productive and law-abiding members of society. So for those reasons, they ultimately concluded with the Amish.
You mentioned the Lemon test, and particularly the entanglement test, which tries to maintain separation of church and state. May a government display a religious symbol, such as the creche on courthouse steps at Christmas time, which seems to favor the Christian belief as opposed to all others? Is that permissible, or is that an unfortunate entanglement of church and state with regard to religious symbols?
We would say that religious displays on forms of public property is legal and is protected, but they cannot violate the Establishment Clause or be a signal of the state sponsoring a sort of religion over others, nor can they be an example of the state attempting to suppress alternate people from practicing their forms of religion or their ways of life.
An example of religious beliefs coinciding with the federal government would be in the case of Lee versus Wiseman, which said that a non-denominational school prayer could not be held at a graduation ceremony. And because it was a private school, however, students could use that time could later use the time to independently pray as a group. However, they couldn't force anyone to join them in their prayer.
Touched upon the orders that have been put forth by the government during the coronavirus pandemic. Can a school require that students be vaccinated against the coronavirus, against a parent's religious beliefs, before being allowed to return to school?
So specifically in the state of Kansas, that is often up to the discretion of the school district. I know examples that are certain cases in the ideas of masks, which is different than vaccines, but is similar in some ways, that you can often receive some sort of a doctor's note to not have to wear a mask in certain situations. Likewise, however, there are examples in the state of Kansas where if a family was a non-vaccinating family, they could instead attend a private school or a homeschool in their own family.
But does the state have the authority to issue that kind of an order?
Yes, I think a state does have the authority to make that kind of order, mainly when we look at the precedent of mask mandates. A lot of states actually like made mask mandates for the citizenry. So the answer to that question would be yes.
Do you think there's an entanglement problem with Title IX and religious schools that receive federal funding?
Could you elaborate a little bit more on, or restate that question?
Sure. Do you think that there is an issue with the fact that religious schools can receive federal dollars? You talked about Title IX in your prepared remarks.
We would say that private schools cannot receive federal funding, but federal funding is allocated per child, which means that private schools could participate in using federal funds.
All right, I'll give you that last answer, even though the stop sign came up right around the same time you could finish your thought. All right. Well, thank you very much for your presentation. It was well done. You should be proud of yourselves. Your teacher should be proud of you. You should be proud of your teacher for the work that has been done on this case. You took the position from the beginning that you agreed with the decision, but then you kind of talked about basically what you agreed with was Justice Douglas's dissent, which isn't really what the decision is. but it's maybe where you think it should go or might go in the future. So that was a little bit contradictory as far as getting a full understanding of that. I'm really curious about some of the comments that were made about divorce cases, and that the child gets to be asked where they want to live. And I'm curious as to whether that's something in Kansas law that you've discovered through your work, or if that's something that you believe the law is, or if there's a certain age. I can't remember who specifically asked that.
Yeah, in Kansas specifically, there's no age where they draw the line as to where a child gets their opinion or not. But in
Okay.
Kansas, yeah, they do get a say.
Okay, that's not something that we have in Washington State. The court has the ability to make an inquiry if the court chooses, but it's very, very rarely done. Not trying to put kids in the middle of that situation, but I was just curious based upon that comment. But again, thank you. Very well done. Mr. Volpe?
Yes, I too congratulate you on your hard work this semester. I congratulate you on making it to the national finals. I think you should be very proud of yourselves with regard to what you have accomplished. It is always so amazing to me that 17-year-olds and whatever age you may currently be have this kind of knowledge. You're way ahead of the general voting public of the of America. And it goes to the value of this particular program. I thought your presentation had some excellent details. I like the Thomas Jefferson and James Madison quotes on the importance of education. Good reference to the 10th Amendment. And then you came up immediately with the provisions in Kansas with regard to the guarantee of an education. You took a very interesting position, as has already been pointed out, with regard to the Wisconsin v. Yoder case. You agreed with it initially, but then talked about the fact that you disagreed with the impact on the students themselves. I like the fact that you came up with the Lemon test and quoted the 3-prong tests that are applied in that particular test. And you came up with Cochrane, you came up with Everson v. Board, and the child benefit theory with regard to school funding. I thought it was interesting that you did not seem to have any objection to the display of religious symbols that tend to favor the Christian faith with regard to public buildings and public parks and the like. But you seem to be okay with that, and that's very, very interesting, because the Supreme Court has been on both sides of that question with regard to cases that have come before it. The children's rights must be respected, I think is an excellent position for you to have taken. And you were good on school funding with regard to whether or not schools can receive federal funding. And I think it also would have been interesting to talk about whether or not state and district school taxes can be used to fund religious schools. But all in all, it was a very good presentation. You should be very proud of yourselves.
I agree. I thought you all did a great job. You seemed very deep in the Yoder case, and you were able to pull back to it and bring forward some of the analysis that the court did when you were responding to our follow-up questions. So good job showing us your depth there. I too was interested in your analysis on the child's decision needed to be weighed, and I think there's a question there of, you know, is that how are we actually serving the child's interests if they have to take their parents to court or rely on, you know, I mean, Yoder's settled law, so the school district isn't going to do it for them, right? So who does protect the child in these situations where the religious belief is prevailing? And the example I cited you is not a totally made up example. There are certainly religious sects that do that. So I thought you did a good job kind of bringing some of your principles-based arguments forward in the follow-up. Would have liked to see maybe a little bit more case law, show us a little bit more of your breadth, because we know you probably have it, and it's really tough to remember cases when you're in the hot seat and spitballing with us, but you were very thoughtful in all of your responses, and you perpetuated a dialogue, which is great. So it was fun to talk with you all. Thank you.
Thank you.